The Supreme Court chamber fell into a heavy silence as Justice Amy Coney Barrett delivered the unanimous decision, a ruling that would accidentally place a $27 million regulatory fine on Elon Musk's newest AI empire. In the back row, Musk sat motionless, his fingers steepled over his mouth, his expression unreadable. No one expected what happened next. As Barrett finished reading, Musk stood, pulled out his phone, and typed a single message. Within seconds, every phone in the courtroom buzzed simultaneously. Justices glanced around in confusion. Court officials grabbed for their devices, on every screen the same notification. Challenge accepted, see you Monday. In that moment, Elon Musk didn't just reject the court's authority. He set in motion a confrontation that could redefine the future of technology, free speech, and government power. Before we dive deeper into the story that has Washington in shock, make sure to like and subscribe so you never miss our latest political coverage. Justice Amy Coney Barrett, appointed in 2020, had built a reputation as a constitutional originalist, meticulous, independent, and at times surprising across ideological lines. The case before her, United States versus Neural Systems, Inc., had seemed straightforward. Did AI-generated content fall under existing speech regulations? But hidden in Barrett's careful wording was a landmine, an obscure provision from the Communications Act of 1934, automatically triggering penalties when tech circumvented federal oversight. Without intending to, the court had just fined Musk's Neural Systems $27 million. For Musk, the money was irrelevant, pocket change for the world's richest man. The principle, however, was existential. Neural Systems wasn't just another tech project. It was Musk's public promise of AI free from government censorship, the final frontier of free speech. And Barrett's ruling, no matter how careful, struck directly at that dream. The Washington establishment braced for Musk to respond in the usual ways: legal appeals, PR offensives, lawyered statements. Nobody expected what came next. From the moment Musk tapped send in the courtroom, a new battle had begun. That night, confusion reigned. Former Supreme Court clerk James Montgomery appeared on CNN to explain. Barrett's ruling triggered a forgotten clause from 1934. It's technical, obscure, but legally binding. Musk is technically in violation the moment the judgment was issued. Musk didn't wait for legal scholars to catch up. Just 3 hours after the decision, he went live on his own platform, in front of 147 million viewers. Today, 9 unelected judges who can barely use smartphones decided they should control the future of artificial intelligence, Musk said. I'm not paying their fine, and on Monday, I'll show America why. The cryptic broadcast shook Washington to its core. At the next day's press briefing, Press Secretary Dana Williams faced a barrage of questions. The administration expects all citizens, and including billionaires, to comply with Supreme Court rulings, she said stiffly. Pressed about Musk's next move, she admitted, "Your guess is as good as mine." Meanwhile, the pressure on Barrett mounted. Conservative commentators, normally her staunch allies, began questioning her judgment. Tucker Williams asked bluntly, "Is Barrett blocking American innovation in the name of technicality?" Even liberal media found itself conflicted, criticizing Musk's defiance while quietly admitting fears over unchecked government power in regulating new technologies. By Saturday, things escalated again. A leaked internal document from Neural Systems revealed Musk had already redirected massive computing power toward a new project, codename Barrett Override. Legal experts debated whether Musk's move constituted contempt of court. Former Solicitor General Elena Michaels warned, if Musk deploys AI technology to bypass a lawful ruling, we're in uncharted constitutional waters. And Monday would decide it all, because Elon Musk hadn't just challenged a $27 million fine. He had challenged the very foundation of who gets to control the future, a handful of judges, or the chaotic, unstoppable tide of technological innovation. And America was about to watch it unfold live. The Supreme Court had never faced anything like this, a direct technological challenge to its authority. As speculation reached a fever pitch late Saturday night, Justice Amy Coney Barrett made a rare, public statement. The court's ruling speaks for itself. We expect compliance from all parties. Her brief, measured words only deepened the uncertainty. But Sunday morning delivered a new shock. Across the massive glass facade of Neural Systems headquarters in Austin, Texas, a colossal digital countdown clock appeared, ticking down to Monday at 9:00 a.m. Eastern, the exact moment the Supreme Court was scheduled to reconvene. Camera crews from every major network scrambled to set up outside. Inside the White House, emergency meetings stretched through the weekend. One staffer leaked that the president himself had tried calling Musk, only to receive an automated reply. Currently busy changing the future. Please try again after Monday. The collision course was locked. Barrett and the court prepared to defend the authority of the judiciary. Musk, it was clear, had prepared something unprecedented, and America held its breath. Monday morning broke under an atmosphere of historic tension. The Supreme Court's public livestream crashed repeatedly under the weight of millions trying to watch. Outside Neural Systems HQ, thousands of supporters and protesters packed the streets, divided by police barriers. News helicopters buzzed overhead, capturing crowds that stretched for blocks. "I've been here since 4 a.m., said Jennifer Lawson, a 42-year-old software engineer waving a sign that read, "Code Court, not Kangaroo Court." This isn't just about Musk or Barrett. It's about whether 21st century technology is going to be shackled by 18th century thinking. Across the barrier, Michael Kingsley, a 56-year-old constitutional law professor, held a hand-lettered sign of his own. Supreme Court supremacy, not tech tyranny. The day billionaires override the highest court, he told CNN, is the day the constitutional system begins to fall. Inside the Supreme Court itself, the tension was electric. Chief Justice Roberts had called an emergency meeting with his fellow justices 30 minutes before the session. Whatever happens, he reportedly told them, we must present a unified front. This could be the greatest challenge to the court's authority in modern history. At precisely 9:00 a.m. Eastern, as the justices took their seats in Washington, every screen at Neural Systems headquarters lit up with the face of Elon Musk. Simultaneously, Musk went live across all his platforms, instantly reaching over 200 million viewers, a larger audience than any presidential address in history. "Good morning, America," Musk began, calm and composed, dressed in a simple black t-shirt against a stark white backdrop. "Today, I'm responding to Judge Barrett's ruling, not with lawyers, but with what I know best. Technology." He gestured slightly, and the screen split. One side showing Musk, the other showing the live feed from inside the Supreme Court chamber. The justices visibly stiffened. They realized in real time they were being broadcast as part of Musk's presentation, without their consent. Justice Kagan leaned toward Justice Sotomayor, whispering urgently. Sotomayor's frown deepened. Barrett sat up straighter, her face impassive but her eyes locked directly on the camera, as if staring Musk down across the digital divide. Instead of fighting the $27 million fine, Musk continued, his voice unwavering, "I've done something better." The screen shifted to reveal a sophisticated AI interface labeled Constitutional Analysis Engine. Its sleek, minimalistic design pulsed with dynamic streams of information, legal documents being processed and cross-referenced in real time. "This system," Musk explained, "has been trained on every Supreme Court ruling, every constitutional analysis, every legal precedent in American history, over 34 terabytes of data. It can identify inconsistencies, highlight unintended consequences, and propose solutions. In seconds, not months." He clicked off screen, and the display shifted again, showing dense legal documents with highlighted sections. "According to this system," Musk said, "Judge Barrett's ruling contains 17 direct conflicts with prior decisions, and inadvertently triggers 4 federal statutes the court never intended to activate. I've submitted full documentation to every major law school and media outlet in America, simultaneously." The camera cut back to Barrett. Her expression was unreadable, calm, composed, but her fingers had tightened visibly around the edge of her bench. Justice Barrett sat impassive, but her knuckles whitened around the pen she gripped tightly. Justice Alito leaned forward, his face visibly flushing. Justice Kavanaugh lowered his gaze, studying the papers before him with sudden, intense focus. Musk continued, his voice calm but gathering momentum. For example, he said, the court's citation of Section 47.3b of the Communications Act directly contradicts its own 2023 decision in NetChoice v. Paxton, where it ruled that algorithm-based content creation constitutes protected speech. On-screen, highlighted text from both rulings flashed side by side. The contradictions were undeniable. Additionally, Musk went on, your ruling inadvertently activates the Regulatory Flexibility Act's small business exemptions, meaning companies like Neural Systems would be shielded from regulation, not subjected to it. Legal commentators across major networks scrambled to keep up. Former Solicitor General Paul Clement appeared live on Fox News. What Musk is doing is unprecedented. He's fact-checking the Supreme Court in real time, with technology that processes legal information faster than any human could hope to. Back in the livestream, Musk's tone sharpened. But here's the real challenge for the court. I'm not paying the $27 million fine. Instead, I'm donating $270 million, 10 times that amount, to establish constitutional AI research centers at law schools across America. The announcement hit the courtroom like a shockwave. Justice Thomas leaned toward Barrett, whispering, urgently. Across social media, sentiment analysis showed Musk's move spiking with 63% public support. The hashtag #YarDataNotDecrees exploded online. Musk elaborated, his voice unwavering. These centers will open next month at Harvard, Yale, Stanford, Howard, Chicago, and Texas law schools, with 15 more universities joining by year's end. Every American, regardless of wealth or political power, will have free access to Supreme Court-level constitutional analysis, previously reserved for teams of elite attorneys. Outside Neural Systems headquarters, the massive crowds erupted into cheers. On live TV, a young law student practically beamed, "This changes everything. I won't need to take on $200,000 of debt just to understand my own rights." Musk wasn't finished. And finally, he said, to demonstrate my respect for the court, while protecting innovation, Neural Systems has restructured as of 8:59 a.m. this morning. He pulled up official documents with visible timestamps, proof the changes had already been executed moments before the Supreme Court convened. We've created an open-source foundation. Our core AI technology no longer belongs to any company or any government. It's maintained by a decentralized network of developers in 51 countries. The U.S. government can regulate Neural Systems, but the technology now belongs to humanity. He looked directly into the camera, as if speaking to Barrett herself. You can regulate companies, Your Honor, but you can't regulate ideas once they belong to everyone. The constitutional principles you've sworn to defend, Musk added, are now more accessible than ever before, not just to the privileged few, but to every citizen they were meant to serve. The brilliance of Musk's move became clear. He hadn't defied the court. He had complied with the ruling, technically, while rendering its impact obsolete. By publicly funding constitutional analysis tools for ordinary citizens, Musk had transformed himself from a defiant billionaire into a champion of democratic access to justice. On MSNBC, constitutional scholar Akil Reed Amar summarized it bluntly. This is the legal equivalent of a chess grandmaster pulling off a surprise. Made in 3. Barrett thought she applied a regulatory check. Musk turned it into a position that changes the whole board. In Austin, supporters held signs reading, "Access to Justice for All. AI for the People." Neural Systems employees distributed tablets loaded with simplified versions of the constitutional analysis engine, showing ordinary Americans how easily they could navigate complex legal arguments once hidden behind walls of elite privilege. Back inside the court, Barrett faced a brutal, no-win decision: challenge Musk, and risk appearing to fight against transparency and open access to justice. Accept his compliance, and watch the balance of regulatory power permanently shift. The room held its breath. History was no longer being written in legal briefs. It was being coded, streamed, and broadcast live. Barrett's intended regulatory framework was dissolving before her eyes. The Supreme Court chamber sat in heavy, suffocating silence, 30 agonizing seconds that felt like an eternity on live broadcast. The justices exchanged glances, but no one spoke. Millions of viewers around the world waited, wondering if the court would call a recess, hold Musk in contempt, or simply crumble under the pressure of the moment. At last, Barrett spoke. Her voice was steady, her control precise. But the strategic defeat was unmistakable. The court acknowledges Mr. Musk's payment of the assessed penalty, she said. Regarding his additional announcements, we will review their legal implications appropriately. Chief Justice Roberts leaned in, his tone firm. This court has always supported informed civic participation. However, we remind all parties that the Constitution assigns judicial power to the courts, not to private enterprises or technologies. We will address these developments fully in due course. The session continued with other routine matters, but the damage was done. The public narrative was already forming, too fast for the court to contain. Across social media, news networks, and law schools, the story was clear. Barrett had unintentionally ignited a quiet revolution in legal technology, and Musk had transformed a punishment into perhaps the most influential legal initiative of the 21st century. A viral post summed up the mood perfectly. Barrett tried to make Musk pay. Instead, she made him the man who changed how Americans access justice. Forever. Within hours, the impact was everywhere. The hashtags #Barrett Backfire and Don Musk Masterclass competed for the top trending spot, with combined mentions exceeding 4 million by midday. Law schools reported being overwhelmed with inquiries about the new constitutional AI research centers. Harvard Law's website crashed under the unprecedented traffic. Neural Systems stock, after an initial 17% plunge amid panic over restructuring, rebounded spectacularly, closing 31% higher as investors grasped the brilliance of Musk's move. This is the most consequential development in legal technology since LexisNexis was founded, declared Stanford Law Dean Jennifer Martinez in an emergency faculty meeting, live-streamed to 40,000 viewers. We need to rethink everything, our curriculum, our methods, because AI can now process precedent faster and more rigorously than any human research team. On Capitol Hill, reactions split in unpredictable ways. Senator Josh Hawley, usually a vocal tech critic, called a press conference. "I've hammered big tech for years, but democratizing constitutional analysis? That's exactly what the founders envisioned. Ordinary citizens, not elites, understanding their own rights." Progressive Senator Elizabeth Warren struck a more cautious tone. "While improving access to legal information has clear benefits, we must ensure that Mr. Musk's system doesn't just reinforce existing biases or become a shield for corporate power against necessary regulation." Meanwhile, Barrett faced an unprecedented situation. Conservative legal scholars rushed to defend her original ruling but admitted the consequences had spiraled far beyond her intentions. The Federalist Society convened an emergency panel where former Judge Michael Luttig warned Barrett's textualism was legally sound, but Musk exposed the gap between the text of the law and the technological realities reshaping society. The real question now is, can originalism adapt to artificial intelligence? Ironically, many liberal activists, traditionally Barrett's fiercest critics, now found themselves supporting the outcome her decision had accidentally unleashed. The Washington Post progressive legal scholar Lawrence Tribe wrote, "Barrett, in trying to regulate constitutional analysis, accidentally democratized it. I've opposed much of her jurisprudence, but this unintended consequence may do more to empower ordinary Americans than decades of progressive litigation ever could." Cable news coverage was relentless. On Fox News, Tucker Carlson thundered, "Tonight, a billionaire did more to empower ordinary Americans against the deep state than Washington has done in decades." Over on MSNBC, Rachel Maddow countered sharply, "The question isn't whether AI legal analysis is good or bad. The question is, who controls it and who benefits from it?" In a single weekend, everything had changed. The Supreme Court's authority, once absolute, now faced a rival force it had never truly prepared for: technology, faster, freer, and in the hands of the people. And the battle for control of justice in the 21st century had just begun. Should we truly celebrate that our constitutional future might now be shaped by Elon Musk's algorithms? At the White House, officials scrambled for a response as the situation blurred traditional political lines. After a tense 3-hour meeting with senior advisors, Press Secretary Williams delivered a cautious statement. The administration respects the Supreme Court's authority and Mr. Musk's compliance with the financial penalty. We are currently assessing the implications of these new initiatives on existing regulatory frameworks. Behind closed doors, fierce debates erupted. A West Wing staffer anonymously told Politico that the room was split, half feared the precedent of a billionaire sidestepping government authority, while the other half argued it was an opportunity to empower citizens. One senior advisor voiced the dilemma bluntly. How do you regulate an AI system that's already been distributed to universities across the country? It's like trying to regulate air. At the Department of Justice, Attorney General Marcus Reynolds told reporters, "We're evaluating all legal options." Yet sources revealed that DOJ lawyers were already using Musk's constitutional engine to assess potential challenges and finding few viable paths. 5 days later, Justice Barrett made her first public appearance at a judicial conference in Chicago. Security was unprecedented. Protesters from both sides, pro-Barrett and pro-Musk, lined the streets. When moderator Jeffrey Rosen inevitably asked about the situation, Barrett answered with striking candor. The court's role is to interpret law as written, not to predict every technological implication. If our ruling inadvertently advanced public access to constitutional analysis, that serves democracy, even if not in the way we anticipated. Her use of inadvertently, rather than accidentally, was noted by legal analysts, signaling a subtle effort to reclaim agency in the rapidly evolving narrative. Barrett continued, "The Constitution doesn't belong to the court. It belongs to the American people. Technology that makes its principles more accessible aligns with the founders' vision of informed civic participation." Her remarks earned a standing ovation. A photo of Barrett receiving applause graced the front pages of newspapers the next morning. Meanwhile, Musk's constitutional AI made its first major impact just 2 weeks later, identifying a conflict in federal environmental regulations that had stalled renewable energy projects for years. The Environmental Protection Agency swiftly issued clarifications based on the AI's analysis, solving a decade-old bottleneck. Public approval for the system soared to 78%. Everyday Americans quickly embraced the tool. In Arizona, Maria Delgado used it to challenge an eminent domain claim, saving her family farm without spending $50,000 on lawyers. A small business in Maine successfully navigated FDA regulations. A disabled veteran in Georgia uncovered benefits long denied to him. Each success story strengthened public support. Legal scholars rushed to analyze the shift. Harvard Law professor Rebecca Chen's piece in the Yale Law Journal went viral. Barrett and Musk inadvertently collaborated to create a new paradigm. Courts will continue to define legal boundaries, but now ordinary citizens have instant, sophisticated tools to understand and engage with them. This fundamentally alters the power dynamic between government and governed. Law schools reported a 34% increase in applications. Curricula rapidly evolved to prepare students for a world where AI handles basic legal research, while humans provide context and judgment. Congressional hearings soon followed. Testifying before the Senate Judiciary Committee, Musk was asked by Senator Ted Cruz whether he had pre-planned his response. Musk smiled and said, "Neural systems had contingency plans, but this specific response? It was improvised after the ruling. The irony is beautiful. Judge Barrett's fine created something neither of us planned, a more accessible legal system. Internationally, reactions varied. The EU accelerated its own legal AI initiatives. China restricted information about the engine. India partnered with Musk's research centers. Kenya adopted a modified version to strengthen its courts. The transformation was profound. Law firms adapted, seeing a 40% reduction in billing for basic research, but an increase in demand for high-level constitutional strategy integrating AI insights. Government agencies started consulting constitutional AI centers before issuing new regulations. Congress used it to vet constitutional challenges preemptively. A Georgetown study revealed that in the first 6 months alone, over 1.2 million Americans used the system to address personal legal issues, with success rates dramatically higher than traditional self-representation. Barrett and Musk, once perceived as adversaries, were now seen as unlikely collaborators in a profound modernization of America's legal system. In a rare interview with The Atlantic, Barrett reflected, "Our job is to interpret the Constitution, not to limit how its principles are accessed. The framers intended for it to be understood by their citizens, and ours." Musk put it more simply, in a post that garnered 3.7 million likes. Sometimes accidents make history. Their eventual meeting at a Constitution Day event, awkwardly but amicably shaking hands in front of the original U.S. Constitution, became an iconic image of tradition and innovation merging. Legal historians compared this moment to John Marshall's establishment of judicial review and the Warren Court's expansion of individual rights. Northwestern law professor James Montgomery titled his bestseller, The Barrett-Musk Revolution, arguing, "What began as an accidental fine may ultimately prove as consequential to constitutional development as any Supreme Court decision in a century." The legal profession kept evolving. Bar associations rewrote ethical standards for AI-assisted practice. Law schools redesigned programs around AI-human collaboration. Government agencies integrated technology into regulation processes. As Senator Cory Booker summed up in a viral speech, "Throughout our history, America's greatest strength has been turning conflict into progress." The accidental collision between Justice Barrett's constitutional vision and Elon Musk's technological innovation may have given us the most significant advancement in constitutional accessibility since We the People. The Barrett-Musk confrontation, once seen as a clash, was now understood as a transformative moment, proving that in the intersection of law and technology, the most powerful revolutions often come from the most unexpected places.